Many times they have persecuted me from my youth up, yet they have not prevailed against me. Psalms 129 and 2. In this video, we will dig into the testimony given during the pretrial stage as well as the co-defendant's plea and the contradictions of perjured testimony that was given and accepted by the courts during Jeffrey Davis's trial. We will see that Jeffrey is not the only one who was victim to the system. As you may remember from the first video, Jeffrey Davis was arrested on August 13, 1991. He was brought in on a trespassing warrant from earlier the year. A few hours after his arrest, the homicide detective would have us believe Jeffrey requested to speak with him and gave a taped statement implicating himself and two co-defendants in the following crimes. Count 1, murder in the first degree. Count 2, attempted robbery with firearm. Count 3, shooting with intent. Count 4, robbery with a firearm. Count 5, shooting with intent. Jeffrey has no recollection of this interview and has repeatedly spoken out on its legitimacy. He could have bonded out on the trespassing warrant and went home the same day. Requesting to speak out on any further crime, especially a serious one he did not do, makes no sense. Jeffrey was not a snitch, but the detective made him out to be one in their testimony. They would not enter the recording in evidence or use it to convict him or the other co-defendants, and would only say what Jeffrey basically said or said in essence. If he gave a statement as to his co-defendants' involvement, why was his recording not used in evidence against them? Jeffrey has stated that when questioned about the crimes, he gave no testimony about anyone's actions except for his own. Under cross-examination, the detectives would go on to say that Jeffrey Davis only said he was present during the crimes and had nothing to do with the planning of them or any shooting or robbery that took place. There were many others present per the victim's testimony. Remember, John Johnson said as many as 20 people were around the car when Broomhall was shot and robbed. According to statements made by the co-defendant, Monroe Alexander, the state would use this questionable testimony about Jeffrey Davis to put pressure on the then 17-year-old. They would tell him his co-defendant spoke out against him, and he should take a plea and testify against Jeffrey Davis in order to keep Jeffrey Davis from testifying against him, telling him he would receive the death penalty if it went to trial. They dropped counts 3 and 5 and gave him life on count 1, the murder charge, and 20 years on count 2, the robbery with firearm, and 20 years on count 4, the attempted robbery with firearm. The two 20-year sentences would be served together after the life sentence was complete. He was also ordered to pay $250 to the Victims' Compensation Fund and a $500 fine. You will remember from the first video, Jeffrey Davis was found guilty on all 5 counts and received 50 years each, running consecutively, as well as ordered to pay $8,000 to the Victims' Compensation Fund and a $4,000 fine. This shows considerable leniency was given in exchange for testimony against Jeffrey Davis. Let's explore that testimony now and the difference of opinion between the plea that was accepted and the testimony of the victims given in preliminary hearings of October 28, 1991 and February 24, 1992. We will begin with counts 1 through 3, which involve the first car and the homicide. Monroe Alexander admits to having the gun and shooting into the car. He then goes on to state someone from the passenger side had started shooting and that it was the third co-defendant. He claims to have shot a couple times, and upon walking away from the car, Jeffrey took the gun, stating, "You got to finish it up." He says Jeffrey then stuck his hand in the car and started shooting. Then they drove off. In the October 28, 1991 preliminary hearing, John Johnson, the backseat passenger of the second car, could not recognize anyone that was there. Of the first car. Could not recognize anyone that was there because it was too dark. He testified they had started shooting once they had started to pull off. Richard Hicks, the front seat passenger, testified he too could not recognize anyone because it was too dark, but one of them pulled a firearm and shot. It was right as they were pulling off. In the February 24, 1992 preliminary hearing, John Johnson testified the driver was punched and put it in drive and took off, and then the gunman began to shoot at them. Richard Hicks testified that the gunman fired at the back of the car as they backed up and once into the car as they were driving off. Both Johnson and Hicks testified there was only one shooter, and Alexander admitted to shooting into the car. Neither victim testified of another shooter grabbing the gun and shooting into the car. If we look at the timeline, they both stated the car was in motion as they were getting away to a safe place. There was not time for Alexander to walk away, Jeffrey to take the gun from him and stick his hand into the car and shoot, all while the car was in motion and leaving. The testimony of the victims does not corroborate the plea of the co-defendant. Let us look at counts 4 and 5. This involved the second car and Richard Fogelman, who was robbed of $10 at gunpoint and shot once in the chest. Monroe Alexander would testify in his plea that he did not have the gun, but did snatch the money away from the victim. He claims Jeffrey Davis and the third co-defendant had guns, and they were the ones who fired shots into the car about 4 to 5 times, and then the car drove off. The February 24, 1992 preliminary testimony of Richard Fogelman tells a different story. He came to Apache Manor to buy crack, and after purchase, the 3 men approached his car. He pointed out Monroe Alexander as the only one with a gun and the one who shot him. He testified that the third co-defendant was encouraging Alexander to shoot him. He said Jeffrey Davis was in the back and did not say or do anything. After hearing the gun cocked, he pushed it away and it went off, shooting him in the chest. He immediately stepped on the gas and got out of there as fast as he could. It is obvious the victim's testimony does not corroborate the plea given by Monroe Alexander. That did not stop the courts from accepting his plea, and in exchange for his testimony against Jeffrey Davis, dropped both shooting with intent counts. He would owe only $750 in total fines, but when released, as opposed to Jeffrey Davis's $12,000 in fines. We believe a great deal of this has to do with the pre-sentence investigation that Jeffrey Davis' attorney agreed to. It is full of misinformation and outright lies. Interestingly, it states Fogelman has been shown photo lineups containing the photographs of Davis, Alexander, and Grayson. Fogelman failed to identify anyone from the photographs. Upon further investigation, and a later date of February 20th, 1992, Fogelman identified Larry Grayson, Monroe Alexander, and Jeffrey Davis from a photo lineup, according to the Tulsa Police Offense Report 27515. However, it shows on the initial affidavit filed August 30th, 1991, that on August 20th, 1991, the victim, Richard Fogelman, identified Monroe Alexander III from a photo lineup as the person who shot him on August 13th, 1991, and as the person who took money from him during the robbery. It goes on to make statements on Jeffrey Davis' behalf that are paraphrased for clarity. For those that do not know, Jeffrey Davis speaks clearly, and his English is completely understandable. There was no reason to paraphrase or say what he basically said or said in essence, but that is what they did throughout the preliminary stages as well as his pre-sentence investigation. When you do this, you have freedom to add or take away from what was truly spoken. You may add names or anything else you would like to make the story fit your narrative. This should not be allowed in a court of law. Worst of all was the summary of the pre-sentence investigation. A pre-sentence investigation is read by the judge before his sentencing of the defendant. Remember, Jeffrey is being tried by the same judge that accepted Monroe Alexander's plea deal. He already has accepted a plea that contradicts the victim's testimony, and we believe he is prejudiced against Jeffrey from the start. Jeffrey Davis's summary states in the first sentence that he pled guilty to the offenses, which he never did. Even if you look up the case on OSCN website, it says he pled guilty, but this never happened, and there is nowhere in any of the documents of trial that state it did. It goes on to say it was for personal gain, although he never took part in any robbery and no testimony of him gaining anything was heard. It states he joined a gang and sold drugs, but again, no evidence or charges of such statement to back it up. It states he has no remorse and does not accept responsibility for his actions. This would be completely normal behavior for someone who is innocent. Its closing remark says Davis was identified by victims Hicks, Johnson, and Fogelman as one of the assailants, but they were unable to determine who held the guns. We have already seen the testimony showing Hicks and Johnson could identify no one because it was too dark. Fogelman knew exactly who held the gun and identified Monroe Alexander as the shooter. It is no wonder the judge was harsh with the sentencing. He was fed a stream of lies to make Jeffrey Davis look guilty. They were so intent on putting Jeffrey away, the state had another case as backup, and it was dropped at the end of Jeffrey Davis's sentencing. It also had co-defendants involved, and they dropped charges on everyone upon Jeffrey's conviction of 5 50-year sentences, or 250 years total. Please understand that Monroe Alexander was a victim of the courts as well in all of this, and has tried many times throughout the years to make it right. He was a 17-year-old kid who imaginably was scared to death. According to his affidavit recanting his testimony, he was threatened and coerced into making the statements against Jeffrey Davis, and was abandoned by his public defender and refused an appeal just as Jeffrey was. We see in his recant that Jeffrey had no part in the crimes and was not involved. Both Monroe Alexander and Jeffrey Davis have fought all these years to be heard. There are too many accounts to be listed in this video. They both have been denied trial transcripts countless times over the years. Monroe Alexander has tried multiple times to withdraw his guilty plea and recanted his testimony against Jeffrey Davis, but the courts refused to listen. They received denial after denial, year after year. Surely there is something that can be done on a federal level to get Jeffrey Davis's case heard. He deserves a life outside of prison. Surely there is someone who knows what steps to take and is willing to help. Jeffrey Davis continues to pastor the church, G&J's House of Prayer, where God shows up and Jesus shows out, at James Crabtree, and ministers to others, leading them to a better path. He has not let this injustice crush him as they plan for it to. It is our sincere hope and prayer that the right hearts will be moved and he will be home with his family, a free man, soon. Please feel free to contact me at stephdavis1332@yahoo.com with any questions or advice. We appreciate your time and all of the love and prayers. God bless you all.